So thank you very much and for inviting me here today to present my research on the impact of the European Court of Human Rights case law on the constitutional protection here in Romania. In the same time, I'm very honored to present my paper here at the Polish-Hungarian Scientific Forum. And I will try to disseminate, let's say, the Romanian experience concerning this relationship between the Constitutional Court of Romania and the European Court of Human Rights. So first of all, I have to point out the sedes materiae of this relationship. It is our constitution. There are two articles I pointed out in this slide, and I highlighted with yellow the aspects that I want to discuss on this slide. So if you see, the first highlight is that if a treaty Romania is to become party comprises provisions contrary to the Constitution, its ratification shall only take place after the revision of the Constitution. This was introduced in 2003 in our Constitution in order to point out that there is the principle of supremacy of the Constitution, and in this paradigm we have to apply, or we apply international law. In the same time, there was an amendment made at the competencies of the Constitutional Court, and the Constitutional Court gained the competence to review the constitutionality of the international treaties that Romania is to become party. So in this stage of my presentation, we notice that the entering in our legal system of the international treaties has to be conditioned by a constitutional review. Another aspect that I want to emphasize is the second yellow highlight, in which I pointed out that the constitutional provisions shall be interpreted in conformity with the treaties Romania is a party to. So this points out the fact that there is a level of protection guaranteed by the Constitution of Romania. So this level of protection cannot drop below the protection provided by the international treaties. So all the times our rights and liberties, our fundamental rights and liberties, are shaped by our, let's say, historical background, legal background, and of course, and in this paradigm, by the international treaties that Romania has signed. And the third aspect I want to point out in this slide is Article 20, paragraph 2, that says that where any inconsistencies exist between the covenants and treaties on the fundamental human rights Romania is a party to, and the national law, the international regulations shall take precedence, unless the Constitution or national laws comprise more favorable provisions. This part with highlighted yellow was introduced in 2003 at the sole and only amendment of the Romanian Constitution. I pointed out that there was a former decision in 1996 when there was a clash between a national rule, a national law, and an international treaty, and the Constitutional Court gave prevalence to the national law because it was more favorable than the treaty. So we can see that the Constitutional Court, when analyzes, when the challenges of constitutionality of laws, have in mind the level of protection to assure high level of protection for individuals. So it is not a scope in itself to give precedence to the international law, but the scope of the Constitutional Court is to protect rights and fundamental liberties. And only in this paradigm, the Constitutional Court would give precedence to the international law. In the following slide, I point out an interesting decision of the Romanian Constitutional Court when the Constitutional Court established a higher level of protection in a certain case than it provided for a higher level of protection than the level of protection provided by the European Convention of Human Rights. So it was a case concerning the deprivation of liberty during the criminal case. So basically, when a person is arrested during a criminal case, and afterwards the person is considered innocent by a judicial decision, the Romanian legal system provided the same level of protection as the European level of protection, that you have to have an unlegal deprivation of liberty. However, in 2021, the Romanian Constitutional Court gave a higher protection, saying that it is not about only legality, because a measure can be ordered according to law, but in an unfair or in an unjust manner. So if that person is acquitted when you finalize the criminal case, that person can have damages. So it is a level of protection higher provided by our national law than the Convention of Human Rights. Now I will try to make let's say a presentation taking into consideration three aspects: the cooperation between the courts, the frictions between the courts, and the challenges for the future between the two courts. As you may know, when a country tries to get into an international treaty, to ratify an international treaty, to adhere to that international treaty, there is a very positive energy in this sense. It was the case of Romania in 1994, when Romania ratified the Convention of the European Convention of Human Rights, and the Constitutional Court made no exception. So the convention was ratified in May 1994, and the Constitutional Court used the cases of the European Convention in the beginning of May, so before the effective accession to the Convention. However, after the accession to the Convention, there were a lot of decisions in which the Constitutional Court cited judgments of the European Court of Human Rights. I can point out that one of the first decisions in which the Constitutional Court struck down a law considering unconstitutional was decision 81, concerning the sexual relations between adults of same sex, the relationship between them. Before 1994, it was considered a criminal offense, and after 1994, on the impact of the European Court of Human Rights case law, it was not considered anymore a criminal offense. Another case in which the Constitutional Court made use of the jurisprudence of the European Court of Human Rights was the case Pantea in 2003, because till 2003 the Romanian Constitutional Court considered the prosecutors as a court that can arrest persons. And after Pantea, the Romanian Constitutional Court said no more, because the prosecutor is not a court, so it cannot have this competence, because the prosecutor is not independent from the executive. Other aspects I want to highlight is when when the Constitutional Court changed its jurisprudence on the impact, taking into consideration the impact of the European Court of Human Rights case law. One of the first decision concerning this was applying Article 6, the fair trial principle in our case law. So basically, we had a very lengthy procedure in an administrative jurisdictional procedure, actually, and the Constitutional Court struck down that provision, saying that it does not respect the reasonable time exigence from Article 6 of the Convention. This decision was, as I've said it before, made a change in our jurisprudence, because before that decision, that very specific procedure was considered constitutional. In the following cases, these are cases concerning paternity, to do not recognize the paternity. And the second one, the C point, is the case when a person wants to establish his or her paternity. In these two cases, we had decisions in which we considered our norms constitutional, but after two decisions of the European Court of Human Rights, there was a reversal of our case law. So decisions Kroon and others against the Netherlands in 1995, and the second one is Kalin and others versus Romania. However, I will point out two more decisions. The first one in 2010, actually, the Romanian legislator equalized the retirement age of women and men, and the Constitutional Court, reversing its previous case law, said it is okay because it is in line with the European Court of Human Rights case law. And the E point, there are two cases I pointed out, the Valeanu cases. In these cases, the European Court of Human Rights actually stated that in restitution cases, the state has not to pay an historic value of the buildings. Historic value meaning at the moment they were confiscated by the communist regime, but has to pay the value, an actual value calculated nowadays. So taking into account the technical characteristics of the property and the category of the use at the date when the damages are paid. So as you can see, in these five cases, the Romanian Constitutional Court actually reversed its case law and applied the European Court of Human Rights case law. In connection with this aspect, I will point out four situations in which the Romanian Constitutional Court delivered first the decision, and afterwards the European Court of Human Rights legitimized the Constitutional Court's case law, saying that it is okay, it is in line with the convention. I won't point out all the four cases that I brought here, but I would like to point out only the last one, Călin Georgescu against Romania, a decision from 2025. It is about presidential elections. You know that in Romania in 2024, the presidential elections were cancelled by the Constitutional Court. And the person that won the first round of the elections challenged this situation at the Strasbourg Court, but the Strasbourg Court maintained what the Constitutional Court established. Actually, the Strasbourg court said, we do not have competence in this case, so we can give prevalence to what the Constitutional Court of Romania has decided. Challenges for the Constitutional Court's case law. It is the case of Buhuceanu and others against Romania in 2023. It concerns the same-sex relationships. It is an application of the Fedotova case against Russia, but it is an application to the Romanian situation. The Romania do not recognize these partnerships nor marriages between persons of same sex. So Romania was in violation with Article 8 of the Convention, so protection of private life. The then Prime Minister of Romania declared that Romania won't adopt such a regulation to be in line with the European Court of Human Rights decision. And after 3 years, the situation is the same. However, we have at the Constitutional Court a pending case that has the deliberation in the end of January. And it is a case brought by Buhuceanu that tackles this problem. So we will have to see what will decide the court in January, but this is the second postponement of the decision. What about the general courts? The general courts apply directly, of course, the convention, so it has a direct effect in the Romanian legal system. The Romanian legal system, as concerns international treaties, is a monist one. So the courts and the constitutional courts apply directly the case law and the case law of the court and the convention as well. Because of the time, I won't develop the second aspect that I wanted to point it out in this slide. So I will skip at the following slide concerning pilot judgments. Till now, Romania was confronted by 2 pilot judgments. The first one, Atanasiu and others against Romania, is a case concerning restitution of properties that were confiscated by the communist regime. And the second one, Reznives and others against Romania, it concerns the detention conditions for detentions in Romania. So in these cases, the Romanian authorities took measures in order to put the legislation in line with the European Court of Human Rights requirements. However, when it comes about conditions of detentions, this is a continuous problem here. So even if the Romanians have the desire to put it in line, in reality, there are a lot of gaps in this aspect, in this respect. A very difficult case that was solved by the Romanian Constitutional Court came in 2018. So this case concerned a legal conflict of constitutional nature, in which basically the Constitutional Court obliged the President of the Republic to remove from function the chief prosecutor of the National Anti-Corruption Directorate. After this decision, the President of Romania removed the person from that position, but the person concerned made a challenge before the court from Strasbourg and won the case. And explicitly there is a friction between the Constitutional Court and the Strasbourg Court concerning the possibility of access of that person to the national courts. The Constitutional Court in that decision said that the national court can analyze only the legality of the removal from the position, legality meaning points of law, while the European Court of Human Rights said not only legality, but it has to analyze if the decision was right. So the reasons of her removal can be analyzed by the courts. So it was friction between the two courts. However, the consequence of the decision of the European Court of Human Rights were almost zero, because the person couldn't be put back again in her function. And actually, she was appointed as chief prosecutor at the EPO, European Prosecutor Office. Another interesting decision that was delivered recently by the European Court of Human Rights is Danileț against Romania. It concerns the freedom of speech of the magistrates in and the balance that has to maintain exercising this right between particular and general interests. Basically, it is not a case that concerns the Constitutional Court, but it may be in the future, because in this case, actually, the Supreme Court sanctioned a person because of his way of exercising its freedom of speech. And afterwards, we have this decision, Danileț against Romania, in which the European Court of Human Rights give a wide margin of appreciation for the magistrates to exhibit, to express themselves in the public space. However, in this respect, I have to emphasize that the Constitutional Court has a case law, a very restrictive one, that the magistrates cannot manifest themselves in the public space because they have this duty to not to expose the judiciary to a public agenda. So basically, these are the aspects that I wanted to emphasize. I know that it was a very short presentation, but I wanted to point out the way in which the relationship between the two courts evolved from cooperations to frictions to cooperation and to challenges that will bring the future. So thank you very much for your attention.